Therefore, when we appoint these, we must bear in mind you need it in both the places. Your government has the full liberty.
That the responses which we got from the various chief ministers, not all, but various chief ministers, they say that we will like to have our own law of appointing the Lokayukt. To my mind, I would like to be clarified by an eminent lawyer like Arun Jaitley, that can we make a central law which will have its overbearing effect on state, or we can make a model law which the state may accept or may not accept. But here I entirely agree with you that the Lokayukt or Lokpal will have to be established by laws made by the legislature, in case of central parliament, in case of state by the state assembly. If you kindly little clarify it, I will be happy.
Since I think this debate is going to be more candid and upfront than most debates we've had in Parliament, it's a question which is concerning us also. Because here there is a conflict between two principles which arise. The first is we need higher standards of probity. But while trying to achieve that, do we compromise with the federal structure? That's the conflict. How do we reconcile it? And I must straight away say that I shared this concern which the Honorable Finance Minister has said with various groups of civil society, including members of Team Anna who have met us and had a detailed discussion with us. Now, if Lokayukt of the state is going to have some powers under criminal law, their view is that under list 2, which is the concurrent list entry 1 and 2, these powers may actually be with the center. But then the Lokayukt's powers are not only restricted to that, it may also go across to taking action against civil servants and employees of the state government. So when you deal with employees of a state government, who makes a law, the central legislature or the state legislature? And therefore, when I put this question to them, they were also concerned with this fact that we don't want to create a law which may tomorrow be struck down as violation of a federal polity in India, because under list 3 entry 41, state public services and state public service commission is entirely within the domain of the states. And therefore, any antecedent fact to the state service, which is action against them, inquiries against them, which a Lokayukt of the state may fall within the domain of the state legislature. Therefore, one possible option is you can legislate on areas where the central legislature has jurisdiction. Where you find that the central legislature has no jurisdiction, you have two options. Either you leave that part to the states, or under Article 252, with the consent of two states, the central legislature can bring an enabling law. It will be binding on those two states. And then every other state which passes a resolution accepting it, it will be applicable to those states. It will become a model law which will be applicable to each one of the states. So it's an enabling law under Article 252 which can be really brought in by the central legislature. Both options are available to you. And therefore, when you negotiate with various groups in the civil society, with opposition parties, and finally when Dr. Singhvi's standing committee goes into this, I am sure they'll have the best of legal advice as to what areas fall within the central domain, what fall within the state domain, so that we are not compromising in any way with federalism, but at the same time we are able to lay down the highest norms as far as accountabilities are concerned. The second question you have raised before the political parties was, should the Prime Minister be brought within the purview of the Lokpal? Now, we've heard sufficiently both arguments. The first argument was India is too large a country. The Prime Minister holds a very sensitive position. The Prime Minister must be kept out of the Lokpal purview because the Prime Minister will be only accountable to Parliament, and Parliament always is entitled to remove the Prime Minister. But there is two drawbacks in this argument. The first drawback is, under ordinary law, both your Prevention of Corruption Act, your Indian Penal Code and all other penal laws apply to the Prime Minister as much as they apply to any citizen of India. So any public servant is bound by them. The Prime Minister is also under the purview of those laws. An ordinary police officer, where a complaint is lodged, or a CBI officer, today can investigate an offence against the Prime Minister. When you are creating a special procedural mechanism of a Lokpal, you want to suspend the operation of the substantive law, Indian Penal Code of Prevention of Corruption Act, by saying this procedure will not apply to the Prime Minister. That probably does not have much merit. And the government's draft, therefore, must be seriously reconsidered. And the government's draft must be seriously reconsidered, because when you say that the Prime Minister will be held accountable only after he ceases to be a Prime Minister, then the crux of your argument will be, if you find that there is a Prime Minister who is guilty of corruption, we must continue to suffer him and hold him accountable only when he ceases to occupy office. Now, I don't think the world's largest democracy can afford an experimentation of this kind. And therefore, a more rational approach on which a larger consensus is emerging today is you hold the Prime Minister within the purview of this law, but then people have suggested there is the 2001 bill formulation which was approved by Mr. Pranab Mukherjee as the Standing Committee chairperson. There are several functions of the Prime Minister which should really not be a matter of scrutiny. His functions relating to intelligence, his functions relating to public order, his functions relating to national security. Maybe tomorrow you may say his functions relating to foreign policy. Now, I don't have a complete list of what can be included and what can be excluded. This is for the Standing Committee to really work on it. You can keep some areas out where there is a larger public interest involved in keeping them out. But today it will be very difficult to sustain an argument that the Prime Minister must only be held responsible after he ceases to be a Prime Minister. You have asked us what should be the mechanism for Supreme Court and High Court judges. The mechanism for Supreme Court and High Court judges are two at the moment. One is their in-house mechanism. It's a mechanism which has worked in some cases, not worked in some cases. And the alternate mechanism is impeachment. We've discussed this 2 weeks ago in the course of the removal proceedings of a judge of a High Court, where I had mentioned, and I see that as a popular sense of this House, that there is a need to create a National Judicial Commission, both to deal with grievances and complaints and also to deal with matters of appointment. The government's approach appears to be, through your statement, that you want a judicial accountability bill. The civil society is saying, if you want it, please strengthen it. Now, whether you call it a National Judicial Commission or a Judicial Accountability Bill, we have to bear in mind one basic principle. The executive must not interfere in the independence of judiciary. But at the same time, the task of appointing judges and judging judges can't be left to judges alone. And therefore, your original bill, as was introduced by Mr. Moyle, the earlier erstwhile law minister in Parliament, left it to the judges alone. So therefore, the present system, which is the in-house mechanism, will become a statutory mechanism. It won't improve the situation. So unless you are able to seriously consider, and I suggested to my friends in the civil society who had met us, it's an important institutional reform which is required. Therefore, this reform may not be possible in 4 days or 10 days. If you have a Lokpal bill and the House shows its concern, we must seriously think of a mechanism like the National Judicial Commission itself. And I must say, in all fairness to the flexibility and the approach that members of these groups, including Team Anna, had, on each one of these issues, when we shared our concern with them, their response was quite reasonable. Similarly, on the conduct of members of Parliament, on one hand, you need to check graft and corruption. On the other hand, you can't interfere with the primacy of the House. And therefore, there is a constitutional mandate in Article 105 that what if an MP misconducts himself within the House, a member of Parliament is liable for action. After all, have we not removed from membership even members who had taken rupees 5,000? We've removed 11 members who took only rupees 5,000. In the case of a government servant, somebody would have said it's a very small offense, so we can reduce his rank or some other punishment rather than throw him out of his job. We removed elected representatives for compromising to the extent of 5,000. And therefore, there is no presumption that the House, when it comes to probity in relation to the in-house conduct, doesn't take action. As far as any impropriety outside the House is concerned, surely no member of Parliament can claim any immunity under Article 105. And therefore, the response really would be to a major issue that we include conduct outside the House as it is included today. And any law we make should be subject to the provisions of Article 105. You've said what happens to government servants, who has a right to take action because of Article 3 and 11. I have put to the members of the civil society who met us, and I got an impression that even they are agreeable, that the powers of the Lokayukt or the Lokpal could be powers of recommending action. Ultimately, the protection of Article 311 is that there is a procedure prescribed by which a person holding a civil post in the union or the state can be removed. There is a procedure prescribed who can do it. Now, that constitutional provision cannot be violated by the Lokpal Act. And therefore, the Lokpal Act must be subject to, necessarily subject to, those constitutional requirements. There is a serious question, and I would only urge that a cross-section of opinion should be examined by this.
नहीं मिला है जन लोकपाल का। हम जैसे आपने जो कहा बिल्कुल सही कहा, जो संसद सदस्य के संबंध में कि जो भीतर का मामला हो उसमें इंटरफियर नहीं हो सकता है, जो बाहर का मामला हो इंटरफियर हो सकता है। ये जन लोकपाल बिल अन्ना हजारे जी क्या कहना चाहते हैं वो भी जरा बतलाइए ना।
नहीं, मैं उसमें स्पष्ट कर दूं। उन्होंने जो आरंभ में बनाया था तो सदन के भीतर और सदन के बाहर दोनों परिस्थितियों में लोकपाल को अधिकार क्षेत्र दिया था। जब उन्होंने शायद सरकार से भी बात की हो और विपक्ष के लोगों से भी बात की हो, तो संविधान की धारा 105 में जो एक सीमा है कि सदन के भीतर जो होता है वो कोई बाहर की एजेंसी उसका निर्णय नहीं कर सकती, तो वो उनको हम लोगों ने बतलाया और मुझे पूरा विश्वास है कि उनको इसके जो तर्क है, और तर्क जो हमारा है वो अपना निजी विचार नहीं है, वो संविधान के ऊपर आधारित है। मुझे उनका रिस्पांस, मैं केवल कहूंगा, मुझे उनका रिस्पांस काफी उत्साहजनक लगा इस सुझाव पे। तो इसलिए
अरे नरेश जी, देखिए आपकी जब बारी आएगी तो
यही मुद्दा है। एक स्टिंग ऑपरेशन हुआ था और माननीय बहुत से सदस्यों से प्रश्न पूछने के संबंध में कुछ लेन देन की बात हुई थी और सदन की कमेटी ने 11 लोगों को मेंबरशिप से निकाल दिया था। फिर 11-12 जो भी निकले थे, फिर ये शंका क्यों पैदा हुई कि एमपी जो हैं उन पे बाहर कोई एक्शन नहीं होगा, एमपी पे एक्शन ले, लोकपाल विधेयक के अंतर्गत एमपी पे एक्शन होता जाकर नहीं होगा। हाँ ठीक सर, एक्शन लिया कि नहीं कमेटी?
सर, in the
कमेटी
suggestions we have made, and we have tried to persuade, because this is not an adversarial issue, that any Lokpal bill must necessarily be compatible with constitutional values. And therefore, it can't violate Article 105, it can't violate Article 311. And therefore, this is a reasoning. I am sure they are also very mature people. They understand the significance of what we are saying. Sir, the sixth question which you had raised was, can quasi-judicial powers be delegated? Now, this is a question which will require a serious examination. I am sure there are going to be mixed opinions on this, because delegation of quasi-judicial and judicial powers ordinarily doesn't take place. But whether it can in an inquiry process take place or not, or the power of inquiry can be delegated to a special officers created, this is an area which can be a matter of legislative drafting and which can be worked out. Sir, you have, towards the end, said that the object of the discussion today